Ms. Tuva Hamilton. Any other apologies? No. There being none. I'd like to welcome members to this meeting today, and it's been a little protracted, we know. There's been a lot of matters that have intervened. I think Secretary, who also manages a number of other joint select and also sessional committees, have indicated how heavy the agenda has been, and therefore how careful we had to be in terms of scheduling to enable us to cover all the grounds that we have to for this parliamentary year. So my effort today is to recommence the presentations from the various groups and individuals who have indicated an interest to present on this very important piece of legislation that we are about to enact. The Protected Disclosure Act for 2022, commonly referred to as the Whistleblowers Act, is an important tool to deal with corruption and to enable the strengthening of our democracy and, most importantly, the integrity of our stewardship on behalf of the people of Jamaica. I'm going to seek your permission to leave at an early period because I have another engagement with a May investment group. I'm sure you'll be happy to hear that, with the Prime Minister at 11 o'clock. So I'm going to ask our Minister of Justice and member of the team to assume the chair in my absence. So I'd like to proceed then with the agenda, a confirmation of the minutes. The minutes are before you. I take it they're read. The minutes are being confirmed by Member Chuck and seconded by Member Robinson. Any matters arising from the minutes which members would want to raise at this time? No. So let us go directly into the matters at hand.
No, Mr. Chairman.
Sorry, Member Brown?
Yeah, I did ask at the last meeting about research on the best practices international, including the EU directives. Since this is a legislation that was copied from the British in a way, and the British have made changes to it. So I just wondered if any research was done and if the result is available to us.
I'm advised that that an element of research is being done, but is not quite completed, and therefore I expect that in short order, on the advice of the Secretary, we will have better details for you, Member Brown, and he advised me that he will send out the outcome of
Thank you very
research.
much, sir.
So can we then invite the National Integrity Action to make their presentation? Yes, Professor Monroe, he has asked us to have him jump the line in order to meet another obligation that he has this morning. So we will oblige. Professor Monroe.
Thank you very much, Chairman, and gratitude to those who expected to be first, that they have waived their right and allowed me to be the first in line. Let me also welcome the establishment of this Joint Select Committee and the opportunity to make a presentation on the Protected Disclosures Act. At the same time, Chairman, we have to recognize that the last time I was here, in respect of the Integrity Commission Act, I was compelled to congratulate the Joint Select Committee for living within the framework of the Integrity Commission Act by reviewing the Act within the time period specified in the Act. I regret not to be able to do that in respect of the Protected Disclosures Act, but I'm sure this is the exception rather than the rule in terms of the review of legislation as stipulated within the Act itself.
I hope I might have covered that earlier in my initial comments. But
I wasn't aware of that, Chair. Please excuse me, it's terrible. Nevertheless, Chair, as you indicated in your opening remarks, the Protected Disclosures Act constitutes a critical element in Jamaica's anti-corruption framework. Indeed, it was proposed and passed through Parliament as an important element of a comprehensive governance reform undertaken by the Golding administration. And I never fail to mention this, as I would like all of us, citizens and parliamentarians, to be aware, and to perhaps take a look again at the presentation made by Prime Minister Golding on May the 10th, 2011, with 14 different elements of governance reform, of which this was a critical component. The Charter of Rights as well, we're well aware of, and hopefully that Charter of Rights will have a long life and not be too thoroughly, if at all, reviewed after such a short span of successful tenure. We should note as well that this law remains a significant achievement as Jamaica became the first CARICOM state to enact such legislation. A similar law was tabled in the Barbadian Parliament in October 2021. Similar legislation failed to pass the Trinidad and Tobago House most recently as February 2022. And this act, we should note, because our international obligations are of great importance, fulfills obligations on the United Nations Convention Against Corruption, 2005, and Inter-American Convention Against Corruption in 1996. In the latter case, the act before us is a specific outcome of a recommendation made in 2008 by the second peer review of Jamaica's compliance with the Inter-American Convention Against Corruption. It should be noted that only approximately 1/3 of states represented in the United Nations have as yet passed similar legislation. And I indicate these points, Chair, because we are very often justifiably concerned about our governance deficits. We should at the same time acknowledge and recognize when we are leading in relation to pieces of legislation. This review should also take into account that the Protected Disclosures Act is regarded by experts as among the best of its kind. And I refer those of us to take a look at colleague article Dr. Omar Hawthorne, March 10, 2015, in the Gleaner. It is therefore a matter of the greatest significance that this legislation be made to function optimally, not least of all in the context of Jamaica's continuing underperformance in the combat of corruption and in the building of integrity. As it stands now, this is far from the case, that is the optimal performance. This law remains among Jamaica's best-kept secrets, and I want that to be underlined. It remains among Jamaica's best-kept secrets, and arguably the least utilized of the important legislation in our governance arrangements. And I pause to say that our governance arrangements to combat corruption remain quite strong in legislative terms, but not as strong as they ought to be in terms of application and use. In the first few years following its enactment, there was absolutely no protected disclosure in the terms of the legislation. Nobody used the law. In 2017, the Organization of American States Peer Review Group, in keeping with the protocols of IACAC, visited Jamaica to conduct, and here I quote, a comprehensive review of the implementation of the recommendations that were formulated to Jamaica in the report of the second round in 2008 regarding the establishment of effective whistleblower legislation. On behalf of National Integrity Action at that time, I made submissions to the peer group, which was constituted by representatives from Colombia and Trinidad and Tobago, some of which, as we shall see, remain to be implemented, In its report, the OAS review stated the following, and here I quote again, in the approximately 5 to 6 years this act has been in operation, only two disclosures have been made, and both were not considered a protected one. Obviously, Chair, all of us here would agree, and I'm sure you may have made remarks to that effect, that this is entirely unacceptable. To have a state-of-the-art legislation not being known to our people, much less utilized, is something that we would all want to correct. In this regard, I repeat and reinforce one of the recommendations made in 2017, namely that this Joint Select Committee urges that resources be provided for a comprehensive public awareness building program relating to the existence, secondly, the purpose, and thirdly, the facilities for whistleblower protection contained in this important law. To that extent, we noted and welcomed the commitment contained in the third annual report of the Integrity Commission, June 25, 2021, the designated authority with respect to the Protected Disclosures Act. The Integrity Commission in its report pointed out that, and here I quote, the Protected Disclosures Work Program is in the development state. This work program will include the launch of the Protected Disclosures Public Relations Campaign in the financial year 2021-2022. The Protected Disclosures Public Relations Campaign will be geared towards educating Jamaicans about the responsibility of all organizations, not some, not public sector alone, all organizations, to establish protected disclosures procedural guidelines for distribution among their employees. This in an effort to ensure that all employees understand the role of their organizations, the assigned designated officers, the Integrity Commission as the designated authority, prescribed persons and other entities, and the rights of employees, end of quotes. It's almost the end of the 22 has ended. And we have not seen this, and it's a matter I would suggest the Joint Select Committee may wish to interrogate as to where this public awareness program is, especially because of its great significance. In this context, it should be noted that in this report, that is the Integrity Commission's 2021 report, literally 10 years after the Act was passed, the Integrity Commission indicated that for the period under review, 5 matters relevant to the Protected Disclosures Act 2011 were received by the Integrity Commission, end of quotes. This paucity of utilization cannot credibly be attributed to disinterest among citizens in making complaints, since the Commission's report itself indicated that in the year 2021 it received 4 times the number of complaints than in 2019-2020. And I want to pause at this moment because we're all aware of the inform of a dead culture, which we still have a significant presence of and suffer from. But despite that, Chair, increasing data suggests that Jamaicans are willing to come forward and are coming forward without even the protection of the Protected Disclosures Act. And I want to refer in that context to the most recent survey, which was done across the Caribbean, and Jamaica was amongst countries covered in the Global Corruption Report 2019, looking at different entities, including Jamaica. In that report, it tells us, a survey that was done for Jamaica, 73% of Jamaicans believe that ordinary people can make a difference in the combat of corruption. And within that framework, 61% express willingness to get involved in the fight against corruption. But they need to be encouraged and facilitated. In the same survey, it indicated that 50% of our people did not believe government was doing enough in that combat. Nevertheless, the complaints, citizens coming forward, the evidence is pretty clear. Let me cite a couple points. The Integrity Commission itself in 2019-2020, 23 complaints were received, 2019-2020. 2020-21, 91. No protected disclosures acknowledged, but 91 persons came forward with complaints to the Integrity Commission. In that same context, Crime Stop, up to September 30 this year, Crime Stop received 946 tips. 946. That's 80% more than in the same period last year. The Auditor General, her most recent report, I use her words, not mine, quotes, a surge of whistleblower reports. 34 were received in that most recent Auditor General's report, compared to 2019-2020. Guess how many? 6. So what we're seeing, if I may suggest, is an upward curve in people's willingness to come forward, even without being aware of nor utilizing to any significant extent the Protected Disclosures Act. What this to do, Chair and Committee, is to recommend even more forcefully that we need to build the public awareness in order to encourage and to protect those who wish to come forward. So that's the first strong recommendation, the public awareness building. In relation to the law itself, I would like to, and I would wish to reaffirm recommendations and observations made in the 2017 OAS peer review. And there's one in particular. It relates to Section 17 of the Act. Section 17 of the Protected Disclosures Act sets out provisions against occupational detriment. Occupational detriment, as you would know from having reviewed the law yourself, is threats of or acts of victimization against persons who either want to or have, in fact, made a protected disclosure. What Section 17 states, and the OAS report I quote from, it appears that the only instance in which the burden falls on the employer to demonstrate that an employee did not suffer an occupational detriment is when the occupational detriment occurs at or about the same time as a protected disclosure. In other words, I report some illegal conduct or inappropriate conduct under the terms of the law to my employer or to the designated person. The day after that, I get a notice that I'm not going to be promoted, or I will be demoted, as the case may be. The law then places the burden on the employer to demonstrate that this is not as a result of the protected disclosure. But what Section 17 doesn't cover is when 3 months down the road, or 6 months down the road, or 1 year down the road, the employer or the officer says, no, go and get you. And what is being recommended by the OAS peer review, as well as by ourselves, is that even in those circumstances, the burden should be on the employer to demonstrate that the reason for putting the employee in an occupational detrimental position is not as a result of the protected disclosure that was made. NI also recommends that the institution of a system of rewards to incentivize employees in the public and private sectors to make protected disclosures in accordance with the PDA Act itself. It should be noted that this practice is initiated in the United States with great success. Between 1986 and 2020, some $46.5 billion was recovered by way of protected disclosures, with whistleblowers being rewarded to the tune of $7.8 billion. This practice has now been adopted in South Korea, in Ghana, in Slovakia, in Canada, and being contemplated in other jurisdictions. And of course, we see the effect of incentivization in respect of Crime Stop, where the rewards paid out for tips that prove to be substantial are an important incentive, helping to contribute to the extraordinary upturn in reports. For the same reason, Well, we would also point out that the law itself protects against irresponsible reports that have no basis. That's section 23(1). For the same reason that we propose a system of rewards, NIA strongly submits that disincentives to report wrong be as far as possible strengthened. I don't know why we say that. Oh, sorry, the disincentives to report wrong, yeah. Specifically, and this is something of an outrage, we identify the Official Secrets Act, not of 2011, of 1911, as a tool used by unscrupulous officials in the public sector to intimidate public servants who may wish to report inappropriate conduct in a ministry, department, or agency. In that regard, I cite one of the most recent episodes which have come to light. The Sunday Gleaner of November 29, 2020, headlined an investigative report as follows, quotes, "Spending Festival. Audit flags millions in overpayments, questionable hirings, expenditure at the Jamaica Cultural Development Commission." In a follow-up report, the Sunday Gleaner, December 6, 2020, revealed, and here I quote, "Almost a dozen employees of the JCDC have alleged intimidation from some senior officials and even board members since the Sunday Gleaner last week published a report suggesting bad governance at the entity. We were reminded by email," note, these are the employees' report, "we were reminded by email about the Official Secrets Act and warned against speaking to the media." 2020, December. Revealed 2 senior staffers on the reaction of management, 2 workers who had agreed to speak with the newspaper on condition of anonymity subsequently declined to speak. The most minimal probe, Chairman and members, would uncover more examples in which the Official Secrets Act is utilized to defeat the central objective of the Protected Disclosures Act and hence constitutes a major obstacle to Jamaica's ability to elicit employee participation in the combat of corruption. Towards removing this obstacle, we urge, in the strongest possible terms, that this Joint Select Committee recommends the repeal of the Official Secrets Act as one important avenue to facilitate more successful operation of the Protected Disclosures Act. In this regard, Chairman, NIA is adopting a recommendation made in the report of the Joint Select Committee to consider and report on the operation of the Access to Information Act 2002. Do you know when that Joint Select Committee made that report, Chairman, members? 2011. More than 10 years ago, yet this offensive and archaic legislation remains. When the British themselves, who it came from, they have long ago amended it to the point where it's not recognizable as it was imposed on us in 1911. In paragraph 2.13 of their report, the Joint Select Committee submitted, quotes, that the Official Secrets Act was an old piece of legislation which had been enacted in 1911 and last amended in 1939, and that the previous administration had promised that it would have been repealed upon the passing of the Act, that is the Information Act in 2000, Access to Information Act in 2002. We join in the recommendation, quotes, that the Official Secrets Act be repealed and replaced by an act that would include penalties for the release of information that would put the state at risk. In other words, it's not just an open sesame. It would be substituted by an act where information released that would put the state at peril, not release that would show malfeasance at a department or agency, that would put the state at peril, that would still be a punishable offense. NIA commends the above recommendations to the Joint Select Committee and submits that their adoption would significantly enhance the combat of corruption and the strengthening of good governance in Jamaica. May it please you, Chairman, I would want to close my remarks at this point. I was neglectful. I didn't introduce two members of NIA's team. Mr. Marlon Moore is the project officer of NIA and recently joined with parliamentary research intern, which I think many members may know from his work in the Department of Government doing research in relation to private members' motions and otherwise. Javan Monroe, and I claim no affinity except by name, were to explore to what extent there may be a relationship of kinship of some sort. Thank you very much, Chairman.
The only concern with Mr. Moore, Ms. Monroe, you need to get a tie.
There's a formal dress code here when you appear in Parliament and you're not properly dressed. You do not fit the dress code.
Lend your tie.
So you cannot say it in that fashion here.
I'll take some blame for that. I don't think I advised him appropriately.
So, so see if we can find we'll try and find a tie for you so you can use. Okay. I'm going to allow members to ask a few questions. But before, can I use chairman privilege and just ask?
Chairman, may I move?
No, may I just ask? A good presentation, Dr. Monroe. But one or 2 points you raised need some elaboration. Firstly,
Chair, before you get to that, I've seen the dress code relax, and may I ask for the suspension of the standing order to allow the youngster to remain with us for the presentation, since it would cause some disruption. And I don't think we need to be so beholden to the jacket and tie thing in 2022.
Mr. Chairman, I am really alarmed to hear a member of this House asking us to breach. It's a standing order. It's written there. And the clerk of the House has informed every guest coming here as the proper dress code. Why didn't you come without a tie?
Why I asked for the suspension of the standing order.
The matter no longer occurs. Professor Monroe, I like the idea, you see, to get this protective disclosure utilized, the concept of the reward system, which, as you say in paragraph 8, is now pursued by a number of countries, South Korea, Ghana, etc., and others are thinking. Could you elaborate a little bit on that? How would it work in this Protective Disclosure Act? What sort of incentive would you give, to employees, especially where it can be shown that they would be saving the taxpayer, tens and millions of dollars? How would it work?
I must say that with the details of it, we have not thought through, but we felt that the proposal itself is working in other jurisdictions, and in our own jurisdiction, with Crime Stop, where a tip is verified as having substance, that an appropriate reward be paid. So in this case, certainly one would want to ensure that the protected disclosure would be one that has content, and to that extent, attract an incentive. The details of it, I think we could work through. I would love to look at the relevant legislation in Canada, which I have not done, I have to be frank, and Ghana, which are two Commonwealth countries, to see to what extent and how have they configured that incentive.
Could we ask you if you could direct our team members, Ms. Nicole Wright in particular, who is, acting for the committee, to any readings, any material in these respective countries, so we can try to incorporate that suggestion as a part of our recommendations. Okay. I think Member Robinson, then Member Gale, then Member Guy, in that order.
Chairman, I want to associate myself with the recommendations from NIA, in particular the one around public education and awareness. I share the view that the reason it is so significantly underutilized, it's two reasons. One, there's a lack of awareness, and the second one, which you highlighted, there is a fear that if you in fact utilize it, there's a risk of retribution, whether it be job loss or some other form of demotion. So I support the recommendation around the public awareness program, which I believe can be implemented in this era without tremendous costs, utilizing social media channels. I also strongly recommend the recommendation around the repeal of the Official Secrets Act, which I think remains a hindrance to good governance in the country. And you highlighted one case where it was used. I know there are many others where you may not have written evidence, but where it is always put forward as a reason why government employees should not provide information on corruption or the perception of corruption. So I just want to associate with those recommendations, and I hope there are things that we can implement, because all the evidence suggests this is a very good piece of legislation, but simply not being utilized at all.
In your item here, when I see systems of rewards to incentivize employees, you know.
Yeah? Oh, it's working now. Yeah. When I see because here is a situation where you are suggesting to incentivize employees to report, but there can be competing interest in terms of those on the other side who are corrupted that might override the incentives in relation to competing interests. So it would be very good for you to explain to us at another time maybe and provide evidence as to how this works. Another area that I want to ask you about in terms of sharing a view, Professor Monroe, is that, you know, we have a legislation that you have rightfully said have not worked efficiently. And maybe one of the challenges is that in organizations, there are no defined procedures as to how to make the reports. And so, do you agree with me that this is one of the challenges in the organization? Notwithstanding, you know, clause 9 that speak to protective disclosure to a prescribed person. But in organizations that don't have even a whistleblowing policy, it renders the submission of any report from individuals to come forward because they don't know how. They don't know what is going to happen to them. Organizations have not removed that fear of freedom in terms of coming forward. And so I'm asking you if you share the same view.
First of all, let me appreciate Member Robinson's support for two of the recommendations that we have made. In respect of the observations by Member Gale, certainly the issue of how the incentives would work is a very, very important one. But we need to perhaps remind ourselves of what constitutes improper conduct under the Act. It's quite broad. A criminal offense, which is almost self-defined, failure to carry out legal obligations, conduct that is likely to result in a miscarriage of justice, conduct that is likely to threaten the health or safety of a person, conduct that is likely to threaten or damage the environment. I mean, workers in a bauxite plant may see beforehand that what's going to happen, is what happened in the Rehoboam, but be afraid. But I better keep my mouth shut. What this law does, properly construed, is protect that work against occupational detriment, which is also defined in the law. Conduct that shows gross mismanagement, impropriety or misconduct in the carrying out of any activity that involves the use of public funds. Chairman, when we think of the fact that under the Public Bodies Management Accountability Act, the last time I checked, of the 161 public entities listed in the table in the Cabinet Secretary's website, only, well, let me put it to how many are not in compliance with the law? 126. 126 have not reported within 4 months of the end of the financial year their audited financials. Suppose, a worker employee in one of those departments or agencies says, look, the failure to report is not lack of accounting skills, but some thing going on here. But he doesn't know, he's afraid, doesn't know where to go. And then Kavan's point, or I remember Gail's point, about the procedural, the process that would have to be followed, that has to be clarified. The law is general on the point about the procedural, how to go about it, and that needs to be more clearly specified. The procedural mechanisms that would need to be followed. So I think those are legitimate observations, but by just looking at the list of what the law defines as improper conduct, I mean, we can just get an act of reprisal against or victimization of an employee. That's not just a labor relations issue. Under this act, that's a breach of the Protected Disclosures Act with penalties attached, which are set out in the law, which are quite substantial. Maybe I wish it to be heavier, but they're quite substantial as they are now. So I do agree that those are issues that need to be clarified, the procedure, and secondly, to look in more detail at how the incentivization would work. Would an employer then have an incentive to reward silence? And then you get an escalated situation where people are being paid to keep silent because they would be incentivized to speak out.
Member Guy, then Member Lambert.
Thank you very much, Chair.
And then
Prof,
Senator Scott Monkey.
Thank you for the presentation. Just a few concerns I have, or questions. You spoke on the item 7 to the occupational detriment, and you are suggesting that based on how the Act currently is set out, there is no time frame within which this should obtain in terms of victimization to the whistleblower. Do you have any suggestion as to how long this would be in terms of time? Secondly, you said at the last part that you're submitting that the burden should be placed on the employer to prove that an occupational detriment to an employee did not occur due to a disclosure. Are you saying, therefore, that you would substitute that for what currently obtains, where the employee can also make a case that because they whistleblowed on a particular thing, they have been discriminated against in terms of promotion or any other job occupation? The matter of the Official Secrets Act, yes, it is something that I'm glad you have brought it to the fore again, right? And I think I concur with my colleagues who have mentioned it before, that is something that is really not only archaic, but it's from the ages that none of us were born and ought not to be even prior to when it was formulated in 1911, as you indicated. And my concern, though, and I think my colleagues mentioned it, about incentivizing the whistleblower and how a system like that would work, and certainly we could draw from other jurisdictions as to how they formulate their thing. But the latter part of your presentation, just before I ask my question, ways in the balance, because as you have suggested, the employer or the boss or management could incentivize the workers not to whistleblow, and at the same time you have the workers who are incentivized under the act to whistleblow. And then you may find that a situation exists where government expenditure is greater to prevent the whistleblowing than what you would have saved by paying out as a form of incentive to the whistleblower.
On the last point, that to be clearly illicit expenditure. If a department or agency apprehends that an employee in a government body is going to report an improper conduct, and then is going to take public funds in order to say to them, keep quiet and you'll get this, then that would be an offense under, I'm sure, other regulations or law. But coming back to the major point, which when we read section 17, where an employee suffers occupational detriment at or about the same time that he makes a protected disclosure, the occupational detriment shall be presumed to be a consequence of the protected disclosure, unless the employer shows that the act that constitutes the occupational detriment is otherwise justified. In this context, that would not require a significant, you'd substitute for at or about the same time some defined period which it would be appropriate for us to contemplate. We have a trade unionist here who can give some indication of what might be an appropriate time period. But even when it's done at or the same time, the employer has the right and the opportunity to demonstrate that the act was not as a consequence of the protected disclosure. And the same should apply later on. There should be that obligation on the employer. If the employee then says, look, a year ago, I reported that what this bauxite company is doing hypothetically is going to pollute. And as a consequence of that, the pollution occurred. But a year after, my time for promotion comes up, or I fulfill the reasons or the obligation, and I'm told you can't be promoted. In those circumstances, the employer should be obligated to demonstrate that the quote-unquote occupational detriment, the failure to promote, is not as a result of that protected disclosure a year earlier on. May well be that we want to put a time frame in there, and that's a suggestion, but I don't have a concrete, I could do some research on that to see what might be an appropriate time, and I think our trade union colleagues might have thoughts on that as well.
Thank you, Dr. Monroe. If I start with the point about at or about the same time, I agree with you that we should seek to remove that from the legislation. And I don't want to put the burden on Senator Gale and myself as a trade unionist here. You are excluding your own activism. But all of us are parliamentarians, and we just passed a piece of legislation called the Sexual Harassment Act, which allow for complaints up to, I believe, 6 years, Senator Scott Motley. So that I'd certainly, if you want to put a timeline there, adopt the approach in the Sexual Harassment Act, which says that a complaint up to 6 years old can be raised. And I'm sensitive to this clause because there are people who have been removed from their jobs, but who have not necessarily claimed whistleblowing. But I could see, for example, an accountant being asked to sign off on documents for donations, for argument's sake, without the approval of the board, accompanying such, or with the name inconsistent with the board resolution. and such a person may very well be removed from office, but wasn't aware that under the Protective Disclosure Act, such a person could have claimed detriment. And I believe many workers, Senator Gale, have suffered under this. So I share your view that that clause needs to change. I note, Dr. Monroe, that you said in the integrity report there are 2 disclosures, but both were not considered protected ones. So essentially, none went forward over this period. And then you made the point that there's been a surge, maybe having to do with people more seeing things than the knowledge of the law. So I want to ask whether you are aware whether that surge that the Auditor General speaks to include the reports to her and her department, include the requirements of the second schedule, which require full name, address, and occupation of the person making the disclosure. And in our country, with a small population, relatively small geographical size, and the informal for dead culture, whether or not that requirement in the second schedule, in your view, is warranted. And I raise this because Crime Stop has been seen as one of the success stories. But Crime Stop doesn't require you to give the second schedule information of name, full name, address, occupation, and so forth. And so, whether or not the approach from Crime Stop isn't something that you recommend, that even if you incentivize, as Crime Stop does, you can then have a code which Crime Stop gives you, which the Integrity Commission gives, which then allow the person and success of the information to claim whatever incentive, whether that wouldn't be a better approach, encouraging more people to do what needs to be done in the country, to whistleblow. Because, Chairman, the Act speaks about specified disclosure of improper conduct in the public interest, and it is my view that it is not a lack of improper conduct, the existence of improper conduct, a lack of it, why there has been so few or no report. It's not because it's not in the public interest. So something must be wrong with the mechanisms to encourage people to report. And so my issue is, would you support the Crime Stop approach, which will allow for us to take into account whatever incentive we may agree and a greater degree of anonymity, given the nature of this country that we live in? I raise those with you. I share also, in closing, Chair, the need for the Official Secrets Act to be repealed and replaced, if need be, with modern legislation. This is before 2 world wars, you know. And the last amendment, I don't think there's anybody in the parliamentary system that is as old as the last amendment in 39. That's right. So for those reasons, I really share the view that the Official Secrets Act need to go, and this must be a recommendation from this committee. In other words, I'm saying, let us accept yours and other committees' report. A Joint Select Committee of the Parliament in 2011 so recommended. Let us accept it once and for all and keep the funeral. The Queen was 70 years. She's gone. Let's bury this one, which was before Her Majesty. Thank you very much.
Chairman, Mr. Chairman, I stand to be corrected, sir, if I recall that you were a member of that Joint Select Committee in 2011 that recommended the...
No, I don't think I was. I was then, when the Act was passed, I was Speaker. In fact, if you look at the Act, I was Speaker at the time when the Protective Disclosure Act was passed. But I don't recall being a part of that in 20...
Speaking about access to information, Joint Select Committee, which recommended that the Official Secrets Act be repealed, that was 2011, and I again...
Oh, it could be. It could be when I became...
You might have even been chairman of that.
Oh,
Minister
you might
of
be right,
Justice.
Could be.
No, the act was passed, but the Joint Select Committee reviewing the act, which recommended that reviewing the Access to Information Act, which recommended that the Official Secrets Act be repealed, that was 2011. That Joint Select Committee on Access to Information recommended that Official Secrets Act be repealed, and I think you were a member, if not the actual chairman. On the other points, Member Bowen, there's much substance in what you say, and I would want to check, again, the Auditor General's description of what she got as a surge. And maybe Member Robinson can help in this regard. But I recall in the report 2021, it being stated that the persons who made those complaints would have shared with the AG's office or designated person their personal identity on condition that it wasn't disclosed. In other words, it would be different from Crime Stop. That I would want to check as to whether and how far that was the case, and obviously didn't prevent a move from 6 complaints in 2019, 2020 to 34 or whatever it was in 2021. The question would be whether and how far protected disclosures, the procedure, should not require identity. And I would want to give that some more thought. As the law stands now, it does require the individual coming forward to disclose, if I'm not mistaken. And that may need to be looked at, and I'd give it some more thought and reflection.
Donna.
Thank you so much, Chair. Professor has in fact addressed one of the concerns that I had, because looking at the figures that he gave us in relation to the responses to Crime Stop and the Auditor General and indeed to the Integrity Commission, I could not understand why this act has been so ineffective. And one of the responses which I contemplated was because it requires the identity upfront at the time of making the disclosure. So I think I agree with you that that has to be looked at, and that the protection has to be strengthened, because there is no point in your coming forward and then you suffer as a result of disclosing that information. I also wanted to ask you if you thought that the regulations, the fact that there are no regulations, was a barrier in the sense of highlighting the procedure. If you look at the second schedule, for example, it does speak to the designated, let me get the term right, the designated authority being guided by regulations which would be made under the Act to prescribe the practice and procedure to be adopted at any hearing. So if you are going to be making a complaint or a report, but you are not sure as to the methodology which will be adopted after you make that complaint, it might also be a bit of a deterrent. It just has to be, if we're going to be reviewing this legislation, we have to have a clear understanding of what are the barriers to reporting. I am not myself excited about incentivizing the reports, the disclosures. I have been pointed to South Korea and indeed Nigeria by Dr. Hawthorne, who, as you know, was a specialist in this area. But I believe that there are a lot of cultural differences which, when we pass legislation, we must take into account. And I'm a little hesitant, although open to persuasion, that this is a method that we should adopt. Overall, there are many questions as to why we should have an act on the books for 10 years. and literally it has been dormant. And I think that that interrogation is where we must start if we are going to identify the problems which we need to address to make it more effective. But I thank you for your, it has been your very fulsome presentation, which I think has caused us to reflect a lot on what it is we need to do.
If I may, among the first steps, the very first steps, people need to know that this law exists. I mean, literally, I mean, even people highly and well informed, perhaps even in the Parliament, may not be aware of the Act and its content and its significance. Again, I refer to the fact that we're among the first to have this kind of legislation and are still leading the Caribbean, as we have in so many other areas like campaign finance reform. But there does need to be awareness of what exists, even at the same time as we seek to strengthen it in ways that are being discussed now.
Let me say, Professor Monroe, that I'm a little disappointed too that this protective disclosure has not been fully utilized. And a couple years back, when the Integrity Commission was set up, and I had discussions with the President Executive Director, the idea which I promulgated was that the Integrity Commission should be one of the designated authority to really not only manage and utilize this act, but really promote it. And I think I've said to the Integrity Commission, perhaps the best way to get information about corruption is to utilize this Protective Disclosure Act itself. In other words, the publicity or the public relations that is being encouraged, it would be the Integrity Commission that would really undertake it. And I've even said that the Integrity Commission should have a toll-free line, 888-CORRUPT. Like 888 Justice, 888-CORRUPT, so that persons can literally, just like the 311 or the 911, to be able to call in and give information anonymously. No, I'm not denying that you're going to get some malicious allegations, but one would expect that the Integrity Commission would decipher what is useful and what is, frivolous. But it seemed to me that this is where, even before we make these amendments, that this is an area that the Integrity Commission should undertake, to let it be known that this particular act, if you know of misconduct, corruption, wrongdoing in the public sector, that should be a part of the remit of the Integrity Commission, point it out so, matters can be investigated. A lot of it has to do with whether licenses were wrongly granted, whether contracts were improperly awarded. All of these things, to my mind, is things that the Integrity Commission should be interested in and should really be saying to public sector workers, if you know of these things, pass it on to us. And I would hope that, this is something, when they come, I will ask them, why don't you start? You don't have to wait until, we get the amendments to this present legislation. Sure, we want to strengthen it, and certainly not only strengthen it, but we'll also ask the Integrity Commission to work with law reform to put in the necessary regulations to get this thing going. But I think it is very sad that we have a legislation 10 years, a good legislation, and it has not been utilized. At least, even if we feel that a couple dozen cases have been pointed out, it would be of benefit to see this Parliament did not act in vain. Sorry, I saw Mr. Moore, you wanted to...
I just wanted to share your concern, and which is why I cited their report the last report of the Integrity Commission, which pointed out that the work program is in the development stage. This work program will include launch of the Protected Disclosures Public Relations Campaign in the financial year 2021-22. I would want to know when it's going to be launched and why it has not been launched, given the importance of this area of work. It will be geared towards educating Jamaicans about the responsibility of all organizations to establish protected disclosures, procedural guidelines, the point being made by Member Gill, for distribution amongst employees. This is an effort to ensure that all employees understand the roles of their organization, the designate assigned officers, Integrity Commission as a designated authority. This recommendation in that report, I would strongly say needs to be implemented.
Well, to the best of my knowledge, in discussion with the Integrity Commission some time back, that was one of the main mandates. You understand, to be able to use and promote this Protective Disclosure Act. Mr. Moore, you wanted to?
Yes, thanks. If I might, I just wanted to reference the Auditor General's last annual report, and it indicates that her website has an anonymous reporting mechanism, and that is where the preponderance of those 34 reports came from in that period. So the numbers here are 31 via the website's anonymous mechanism and 3 by telephone, constituting that 34.
Sure. Member Robinson.
I wanted to support a recommendation about the making it possible for people to report anonymously. Our culture is still one where there's a great degree of fear. Reprisals are real, victimization is real, and I mean, I can tell you of a case, obviously I won't go into the specifics, where someone in the public sector who I believe provided information related to corruption was not immediately victimized, but 3-4 years later has been overlooked for any form of promotion, has been stagnant in a particular position. Persons less qualified or with less experience have been promoted. So I would also support extending the period where someone feels they're being victimized to equal to what obtains under the Sexual Harassment Bill, which is 6 years. And I do believe it is important because there's the response from the organization in most cases is not immediate.
Member Gill.
I just want to make 2 points in terms of where Member Robinson left off, and Member Brown would have raised it in terms of the 6 years. The context in the Sexual Harassment Bill for the 6 years was suggesting that someone would have suffered in silence for that extended period. And, we have to be very clear that we are utilizing the similar context in which is being suggested here. But I want to go to part 3 of the legislation, the provisions against occupational detriment, because that is one of the clear areas why a number of employees might not come forward because of the fear of occupational detriment. And whilst it presents the rationale here in 16.1, the employee shall not be subject to any occupational detriment, and in 2, an employee who is dismissed as a consequence of seeking to make or making or intended protected disclosure shall be treated as being unjustifiably dismissed. The only way you can treat with that unjustifiably dismissal is to take the matter to the tribunal. But in part 3, there's no defined consequence against an employer who promotes occupational detriment. And I'm suggesting that when we are reviewing this piece of legislation, we may want to consider to highlight that there can be consequences laid out against an employer who causes occupational detriment. Don't leave it to just that the worker might have to go defend themselves, but there are known established consequences for employers.
Yes, and I just want to add to that, Member Gill. This act was meant to expose dangers at the workplace. I mean, so occupational dangers are things which should be exposed, even especially if it has been overlooked and not remedied. And that is the point, you see. So even before the OCHA, you know, this new act that's supposed to come in place, OCHA, that has been, yes, occupational safety. But the point about it is that this is not only for corruption, but it was also meant about dangers at the workplace, various types of misconduct of, you know, by employers and employees in the public sector. So it's a piece of legislation which needs to be promoted. Yeah,
absolutely. Yeah. If I can just add to that, Chair, we saw how broad the definition was in relation to improper conduct under the Act. But 23(1) is pretty clear. A person commits an offense if he prevents, restrains, or restricts an employee from making a protected disclosure, intimidates an employee who has made or intends to, induces any person by threats, remember, promises or otherwise to contravene this act. And then it goes on. Let us look at 20, the offenses. A person commits an offense under subsection 1 is liable. Summary conviction, in other words, a criminal offense, in a resident magistrate's court to a fine not exceeding $2 million or to imprisonment for a term not exceeding 2 years, or to both such fine and imprisonment, or conviction in a circuit court, etc., to 5 years, or to both such fine and imprisonment. So it could well be argued that once that offense is committed, the issue of going to the tribunal would be obviated to the extent that one can prove that 23(1) person, employer has committed any of those A to D. And then the issue goes before the courts, the parish courts or the circuit courts, with those appropriate penalties once they're found guilty. So there is in the explanation on public awareness building, employers would well be advised to pay attention to that dimension of the Act, which specifies what the offense is and what criminal conviction would entail.
Okay, if there are no other comments or questions, I want to thank you, Professor Monroe and NIA, but also to remind you that you have some obligation to give us some additional material to Ms. Nicole Wright in law reform as we contemplate further, exploration to improve the Act. So thank you very much, you and NIA, for your presentation, and we hope from it some useful amendments will be made.
Thank you,
so
Chairman,
thanks very much.
We're very happy to be here, and I'm glad the research intern is here and the projects officer, and I've heard your remarks regarding follow-up,
okay,
which I will reinforce as well. So thank you very much, members of the committee.
Yeah.
Appreciate it.
Okay, we're going to have the second presentation now from the Office of the Services Commission, and I think Mr. Foster, you and Ms. Martin Joseph, Morris Joseph, sorry. All right.
Yes. Good morning, Honorable Chuck, members of the Joint Select Committee. It's a pleasure for us to be here. Myself and Ms. Georgia Morris Josephs. She's the Deputy Chief Personnel Officer, Information Standards and Public Education. My name is Milton Foster, and I'm the Director of Corporate and Special Services. So today we are representing Mrs. Jacqueline Mendez, the Chief Personnel Officer, who is at the PS Board meeting. So we are representing her. We'll be doing our submission as it relates to the reviewing of the Protection Disclosure Act 2011. Much of what we will be saying would have been said earlier. So we'll be reiterating much of the expression. So for example, one of the reasons that we believe that individuals would not have come forward is a lot has to do with definitions. For example, what is considered to be in the public interest? some may not be clear as to what that means. And we believe that a definition of such a term could assist. Specified disclosure, again, that would also require some definition in the Act. And when Section 2B mentions the employer, I hear example being given of the bauxite company. Is that a private entity, or does the Act speak to public sector only? So it needs to be clear because it was a bit vague in terms of reading and interpretation. Also, as it relates to conduct that shows unfair discrimination, one example cited in the Act was political opinion. The team that reviewed the Act also believed that areas such as disability, sexual orientation, other things could contribute to that as well. Willful concealment, we thought that there could be also, other than just listing the areas, we thought that you could leave it open for other means of improper conduct. As it relates to transfer again, Section 2D speaks against an employee being transferred against his will. We thought that in this act, it needs to be clarified because, for example, in the acts such as the Local Government Unified Service Act, it allows for it, and I think the police as well allows for that type of action to be taken, and it is not seen as detriment. So we thought that needs some clarification. A lot of discussion took place as it related to occupational detriment, but we thought that the act needs to go a little further. Mention was made of the informer for dead culture, and we believe that much of the action is not just limited to the workplace. Much of what takes place can be done outside of the workplace. So how does the Witness Protection Program support this act? What about relatives? Some of the time, the reaction is not against the immediate individual, but against a relative. That also needs to be factored in. Mention was also made in terms of how will the person's name above in the second schedule be compensated. So we also thought that there need to be some consideration for that. Will provision be made for the person's life if they are threatened? Would they be insured if the person is killed as a result of coming forward to save money? Is there protection for the designated person who would have received the information and as a result become now a target as a result of the disclosure that is made? So we expanded it further to believe, as mentioned in Section 3, that the act need to include personal attacks and threats outside of regular working hours. The act applies to any disclosure made after the appointed day. Now, we believe that we ask the question, is there a specified time frame for Section 4, on page 5, Section 4, paragraph 1? Is there a specified time frame for the specified day, appointed day? It seemed to be a bit vague. And the question that was asked, that if it is specified, this will indicate how long after an act of misconduct has occurred for disclosure to be made. We hear the proposal of six years in line with the Sexual Harassment Act. Now, Section 6, subsection 2, says where a disclosure is made orally, it should be caused, the disclosure should be caused to be reproduced in writing. Now, the question is raised, after the disclosure has been reproduced in writing, should it be signed by the person, making it valid? Section 7, I'll skip that one. Section 9.1, it says reasonably believe, in part says reasonably believe that the conduct disclosed falls within the area of the responsibility of the prescribed person. We thought that it should also include outside of the area of the prescribed person. It doesn't necessarily have to be limited to that person's scope or work. Section 10.2 mentions the seriousness of improper conduct disclosed. Question is asked, who determined the seriousness of the improper conduct? And if this can be clarified, then it should be stated in the Act. says, where an employee seeks to make a disclosure in relation to the Prime Minister, again, we are in support of the recommendation that was made earlier, that a hotline, a toll-free number, or a 3-digit NNX could be incorporated to allow people to report anonymously without being recognized. And this will be beneficial for a person who do not feel comfortable disclosing information to the designated officer as a result of the high level of mistrust in some organizations, but to be more comfortable making an anonymous disclosure via telephone. Again, in section 12, subsection 2, it says the Prime Minister and each minister referred to subsection 1 may make regulations. Again, this was mentioned earlier. The accompanying regulations, in addition to standard operating procedures, need to be created by, well, we went a little further. We said by the Integrity Commission to operationalize this act, because without it, the act really has no teeth. And we believe that that's one of the reasons why the utilization is that low. It says each employee and prescribed person shall establish dealings with the disclosure. So we believe that the procedures for making disclosures internally should be standardized as well, and that will reduce variation. The procedure shall identify at least one person to whom disclosures can be made. We also believe that putting one person there will put the individual at risk, and possibly you may want to increase that number to 3 designated officers at a minimum. Now, these officers will also need to undergo a fit and proper test to ensure that they are capable and competent to take this type of report, and that they will act in a manner that is sound and with professional integrity. The designated officer shall confer with the requisite authority, this is according to section 3, subsection 4, any disclosure. Now, for the avoidance of doubt, we ask that we specify who is authorized to confer the authority on the designated officer. That was not specified in the Act. It says, section 13, subsection 5, says, where an employee makes a disclosure under this section, every designated officer shall. Now, we thought that there need to be a minor adjustment there. We said we could consider changing the word every with the wording as follows. Where an employee makes a disclosure under this section, the designated officer, and that will put the accountability on the designated officer. The designated officer shall keep the employee updated on the status of the investigation of disclosure. Again, this was mentioned earlier. We are just adding to it. There's no mention of how the updates will be done, whether it be done orally, whether it be done via email, whether it be done in writing, or whether it be done at all in terms of the communication. So we thought that there needs to be some clarification there. Each member shall cause information on the procedure for making a disclosure to be circulated amongst employees of the employer on a regular basis. Now, we thought that statement was vague. We thought that regular basis could be replaced with a more specific term, such as once per year. And again, we could even state at orientation sessions, and also, in addition, we could apply our owner that this can be monitored by the Integrity Commission as part of their monitoring and evaluation to ensure that this act is being promulgated. And as mentioned, in terms of the public education and so forth, they would continue to monitor the entities to ensure that they are in fact doing what they are doing. It says, where an employee makes an internal disclosure, the employee may make an external disclosure in accordance with section 9 or 10. Now, it raises a question. The question that it raises, does this mean that a report must be made internally by an employee first, who must then wait for 30 days within which to make an external disclosure if no action is taken by the employer? Or can the employee make the initial disclosure and the external disclosure at the same time? The current act puts it in a chronological order. Section 16, subsection 2 says an employee who is dismissed as a consequence of seeking to making or intend to make, in part, is unjustifiably dismissed. The question is asked, how can it be reasonably presumed that the person is intended to make a protected disclosure? In other words, under what conditions can an intention be established? It says, where an employee suffers occupational detriment or is unjustified dismissed. That is according to Section 17. The question is asked, how can an employee be protected from further actions outside the confines of the work environment? This needs to be clearly stated in this act, because it keeps on limiting to the working environment alone. Section 18, Part 5 mentions retrieving, investigating, and otherwise dealing with disclosures internally. We believe that we need to include comments on how the information will be stored or otherwise protected. How the information that is reported, how is it that will be kept safe within the organization? That possibly could be included in the regulations. Section 18, subsection 3, make recommendations regarding the measures to be taken to correct the improper conduct. Question again, to whom will the recommendations be made to treat with the improper conduct? Again, that is a question that is hanging. Section 18, subsection 3, take steps to remedy the improper conduct and provide redress. Our comments that is there any recourse to the person being complained about in the event that the information is malicious? Because you did mention, like the case of the telephone calls, you will get those malicious calls and so forth. If it can be established, how do you deal with, for example, defamation of character, or it links to other acts? Section 18, subsection 3, ensure that the right of the employee making the disclosure, any witness or any person alleged to be at fault, are protected. So it's similar to Section 3, subsection C, page 5 above. Again, we are concerned about the protection of the witness. You know, what will happen to this person? And maybe that's the reason why people are not coming forward, because they are aware of the risks that exist. Record risk, subsection 18, Section 18, subsection 3G, receive, record, review, investigate, and otherwise deal with complaints made in respect of reprisal under this act. Again, we ask, is there a time limit in which to deal with complaints made in respect of this act? In other words, you give the complaint, what is the person duty bound now to act? Refusal to deal with a disclosure. Who decides what amounts to an improper conduct that warrant a refusal? Because it gives the designated officer the right to refuse, but who determines that they can refuse? Section 19, subsection 2, it says the subject matter of the disclosure or the related investigation has been adequately dealt with or could more appropriately be dealt with by another person. Again, a question is asked, how do you deal with circumstances related to conflict of interest? This should be clearly stated. For example, where a bias exists due to a person making the disclosure is a close friend or a relative. So that needs to be clearly stated to say that the person needs to recuse themselves if they are closely related to the person, if they are the designated officer. Section 19, subsection 2, in circumstances surrounding the subject matter of the disclosure have changed, where the person, where by reason of a change in circumstances of the employee or the employer, sufficiency of evidence or otherwise, so that it renders the investigation unnecessary. We believe that you could mention specific examples. For example, death. If the person dies, what becomes of the investigation? Person migrate or the person resign, does it come to a close or does it continue? Does the investigation continue? Where an employee decides to refuse to carry out an investigation, decides to refuse to carry out an investigation, the employee shall provide a reason in writing to the employee within 15 days of the decision. Observation has been made based on Part 4, which makes reference to employee-employer instead of the designated officer. So since the report was given to the designated officer, shouldn't the designated officer be the one now that is communicating instead of putting it back to the employer? So it gives that, at that stage you're not sure who you're communicating with, because it now becomes dealing with your boss instead of dealing with the designated officer. The question is asked, is it the intention of the act to make reference to the employer for this purpose? We're not sure. Provisions for non-disclosure being voided. We believe that notwithstanding where a person has been subject to a non-disclosure agreement, similar to what was mentioned earlier, the Secrecy Act, he or she should contact the Integrity Commission if they are aware of any improper conduct. So that would prevent them now from going to the designated officer within the organization and go directly to the Integrity Commission if they are duty bound under such act. Section 21.3 says, on an ongoing basis, plan, implement, and monitor public awareness. Again, we ask the question, is there a monitoring plan? As mentioned earlier, the designated authority, which in this case, according to this act, is the Integrity Commission, should monitor, and we give an example every 2 years to ensure that there's compliance. So instead of leaving it up to the entity, there's a monitoring and evaluation component that will strengthen the act. Section 21.4 says the designated authority shall, and it goes on to say the minister may, in special circumstances, approve, cause to be made, and transmit to the minister a report dealing generally with the activities of the authority during the preceding year. Now, we would have heard reports being made, but Professor Monroe made mention of the 161 entities. Only 126 are not in compliance. So what if the entity that is responsible for providing the minister with the report does not provide the report? What is the consequence? Similar to what was being asked about the non-producing of financial reports. What if they don't produce a report on this act? Is there a consequence? The act doesn't speak to one. This section 22, subsection 2, says this section applies to employee who is likely to be subject to occupational detriment. Again, we reiterate what happened to outside of regular working hours. Section 23D, subjects an employee or former employee of that person to occupational detriment for making a protective disclosure. The category of persons could be expanded to include relatives. We thought that is also an omission. A person who is a resident magistrate court, I think the name would have changed. I think it should change to say change registrant magistrate court to parish court. So that is that I think based on the timeline that would have been a change. In section 23, subsection 2, a fine not exceeding $250,000 or to imprisonment for a term not exceeding 3 years. We consider this a little low, and it would not be a deterrent to persons' behavior. And we thought that maybe $2 million would be a more appropriate deterrent. So we gave some thought to it. The minister may make regulations. This was mentioned earlier. Question is, which minister should make the regulation? Again, the act is limited without regulation. This was mentioned earlier. And when will be the regulation be drafted and by who? The prescribed person to whom disclosures may be made. We believe that the Contractor General should be replaced by either the Integrity Commission or Public Procurement Commission in the case of public procurement, and to add minister to the list of designated authority. It wasn't mentioned there. This was also highlighted earlier, where the full name, address, and occupation of the person making the disclosure. Will there be a consequence if the person refuses to state their address? For security reasons, it is not recommended that an address be required. That was mentioned earlier. And we also mention that in cases that the report is written, there's an absence of a signature and an absence of date to confirm the report. Coming to a close, again, we believe that full name, address, and description of a person who is a witness, we believe that it is not reasonable for a person to give such information, especially in light of the Jamaican culture. We would not see that person very long after this. And based on the third schedule, where for the purposes of an investigation, the witness expenses act, I don't remember what we're trying to say here, but what we believe is that the witness expenses act, like many other laws, is outdated. It doesn't compensate for the person to even make a bus trip to do anything. So we think that needs to be properly amended. Or, it is more in keeping with the consumer price index. And third schedule, it's a typographical error. We believe that therefore was incorrectly spelled. That's it from us.
Right. Thank you, Mr. Foster. This is a very comprehensive review of the Act itself. I must say that just listening and examining a number of the points you raise are matters which the CPC will have to contend with, whether the drafting itself can be modified or improved. It may be that the CPC doesn't think so, but because from the points you raise, you're really looking at the possible interpretation of the relevant phrases and section. And CPC might say, well, it's a matter if it goes to court. That is how the judge one possible interpretation. Yes. So a lot of the points you have raised are very interesting, and certainly the CPC law reform will certainly take a look at it. Definitely some of the corrections that you have pointed out should indeed be addressed, and those will definitely should be addressed. Some of the points you make seems reasonable, that could be improved. Whether the committee will take it on and try to improve. Obviously, the Act itself is undergoing this review, and anything to improve it, to make it more responsive to the needs of the various particular ministries, etc., will be helpful. So your draft will form a part of the overall matrix that when the committee start to look at the individual clauses, your points will be noted as to what can be accepted, what can be examined. So I don't know if members would like to ask any questions or make any comments at this time. Yes, Member Brown, then Member Gill.
Thank you, Mr. Foster. Chairman, let me just say I want to thank all the agencies and organizations that have responded. I believe as a Giant Slate committee, this committee might have gotten the most immediate responses from the public. And it is good that the public has an interest in a legislation that has not been very, if at all, effective. And I thank you and the others who will come later on to contribute. At page 8, you spoke about a monitoring plan. Yes. And it is true that this legislation has not had the full implementation of what the legislation itself said should take place. Designated officers in every employment place. None of that has taken place, and that's part of the work that the Integrity Commission will have to do. I want to ask you, the monitoring plan you speak of, would it be similar to what exists now, whereby government agencies must report to the Contractor General on a quarterly basis, I believe, whether they have entered into contracts and the details of that? And if by that monitoring plan you envisage a quarterly or half-yearly report to the Contractor General by each agency as to whether or not designated authority have been set up, and without any detail whether complaints have been made to them. Simply yes or no, and if yes, the number. And would you be of the view that the number of such complaints should be reported, say, by the Integrity Commission to the Parliament in its regular reporting?
The short answer is yes. What I have here is a copy of the Services Commission draft policy, our guidelines for the protective disclosure. Now, we would want to, what we are thinking is that every entity would need to have one of these guidelines that will help them. And as you mentioned, the monitoring now in terms of the quarterly reporting, the first thing would then establish that you have one, you have a designated officer, and then each quarter now you report in summary form, and the Integrity Commission provide regular update to the Parliament. And that will ensure that it is there. And as mentioned earlier, that would also, they also need to ensure maybe on an annual basis, end of each year, for each entity to indicate that they conducted some form of awareness exercise and to provide evidence of such. And that would ensure that the public awareness is taking place.
Right.
You have a draft policy from the Office of the Services Commission, which means it has not gone out to the 100 and odd bodies. But could that be, the draft be shared with us so we could get a sense of where your thinking is at? And as we take other reports, we could see how that draft would fit into the scheme of the legislation. So I request to you, Chair, for the Office of Services Commission to share with us their draft.
If they are so minded, is that something that is you can share?
Well, we would discuss it with the Chief Personnel Officer, who would give us the authority by whatever means.
Okay. Member Gill, then Member Scott Martin. You yielding to? You should. Senator Scott Martin.
Thank you, Chairman. I want to thank you, Mr. Foster. It's a very thorough analysis which has been done. But as I've listened to you, I've become more concerned about this act, although Professor Monroe said it was the best in the Caribbean. I want to ask you, do you get the view that this legislation contemplates small entities, or is it almost, has it been drafted having a large institution in mind? Because Senator Golden Campbell and I were having a short sort of consultation, and we who have organizations or are associated and affiliated with organizations which are not huge, but where there is a possibility of the need for making such a disclosure, we have to ask ourselves, if you have a designated officer within a small organization, and somebody makes a report to that designated officer, how do you ensure that there's a level of confidentiality which would offer the protection to the person you are concerned about? How would you guarantee that the person who is making the report is not at risk? And having confronted these questions myself, I am more emboldened in my suggestion that this should be anonymous. The consequences of having name and address and the full disclosure to a designated person is exactly why nobody would want to use.
It should not be mandatory.
No, because that's exactly why people are reluctant to use this legislation and have comfort in using a crime stop where they know that the possibility of any reprisal is minimized.
Yes. So we are in agreement with you. We believe that the independent number, which will be in the Act, everybody knows 119, or in this states 911, that this number is a designated number. So once you have this independent number for the disclosure, then everybody would know that it exists. And you don't necessarily, as you said, with a small organization, it is difficult because, some organizations, they're very small, even 5 individuals, who do you report it to? And then now, for occupational detriment, that becomes immediate. So it lends itself to that type of risk. And again, we believe that was one of the reasons why, the utilization of the act was so low. Well, we thought nobody would actually use it. We learned today that there was a few. But we believe that it is not properly structured. It's a bit academic, having a form with name, whatever. It doesn't relate to the Jamaican culture in its true sense.
Senator Campbell, Sherry.
If I could, Chair, thank you, Senator Gill. If I could just ask a follow-up on that, because while I appreciate Senator Scott Motley's position on the anonymity of the person making a complaint, the other side of it is, in that context of anonymity, a person who is complained about has no protection against the complainer if that complainer makes the complaint in a prejudicial and what is the word, malicious, thank you, in a malicious way, and even more so, in the circumstances where it turns out that the investigation reveals no impropriety. When you have an anonymous complaint, how do I protect myself from somebody who doesn't like me, or doesn't like my politics, or doesn't like my family? How do I protect myself? Or doesn't like a decision that I made in the context of the workplace that they may not appreciate? So that would be my follow-up question to Senator Scott Motley's question, and I'd love to hear your perspective on it. And if I could just give you a part 2 to that, I'm interested in hearing what is the experience of the Office of the Services Commission and how you have seen matters like this playing out across the public sector.
All right, so firstly, you cannot prevent it. You cannot prevent malicious actions. People are people, they will be malicious. I use the example from a former life, managing toll-free numbers. You will always get prank calls. One of the things you have to establish is the validity. What percentage is prank versus what percentage is valid? Now, let us say there's an allegation against me. The designated authority would not accuse the individual. You would conduct your investigation. Now, if the investigation proves malicious or false, then it dies, and nothing comes of it. If you can establish who is the person who did it, then you can pursue action. If you cannot, then it dies a natural death. However, if the person was brazen or willing enough to put it in writing, then they would know that they put their own self at risk. In my personal experience, having sat on a few boards and so forth, even in government, we would have seen malicious intent. And for example, in committees, we would base our subcommittees of the board, you would then probe to see if the complaint is valid. And in a lot of times, it's not valid. You see that people are being malicious or they are witch hunting. So once you establish that it is not valid, then you just put it aside and move on. Because the laws and the regulation would clearly show, what did this individual breach. If they can't prove it beyond a shadow of a doubt, then you can't proceed any further. But there need to be some capacity at Integrity Commission or within the organization. I think presently you have the designated officer who basically has their day job, but is assigned the designated officer without any additional capacity to conduct investigation. So would the Integrity Commission be the resource that they would lean on to conduct a discrete investigation without causing any, unnecessary...
Which is the real likelihood. That is the real body, in my view, that should be the designated authority to undertake, serious investigation. Sorry.
Yes, Chair. Mr. Foster, I thank you for your, what I consider to be a very clinical analysis of the legislation. And, it tells us that after so many years, why the legislation is really not working. And I am looking forward to hear the responses from CPC in terms of these analyses that have been made. The act is a protected disclosure act. That suggests in my mind that those making the disclosures must be protected. And so I wonder, what is the need to having an address? Because you're not going to do nothing with the address. Because the disclosure relates entirely in terms of the institution or organization to which an allegation would have risen. So you don't need me address. Just like other legislations that has called for addresses, I can name the Employment Termination and Redundancy Payments Act, that when the employees being made redundant and getting the little money, they must tell the address for the landlord know that they're getting the money. Now, in terms of some observations that you have made, where in 9, you spoke about the question of making the declaration or the disclosure both ways, internally or externally. I kind of like the internal mechanism first, because it inspires confidence that it should work internally before you expose it externally. So I'm liking that idea. I also question this thing about the malicious intent of persons. Because persons can be very malicious, and hide behind a screen with intended causes that are detrimental to your image. So that is an area that, when we're going through the matrix, I'm going to raise some concerns. But I think all in all, you have made some very, very good observations in terms of what we ought to look at. And Chair, this is one of the legislation that, notwithstanding the fact that the prescribed time frame for review was intended to be a short one, but I don't think that we would have arrived at some conclusions that we are arriving today if we had done it within that prescribed period. Not that I'm not saying or suggesting in any way, shape or form that it should not have been reviewed, but the type of analysis and probity that has come from at least the two presenters, and I want to believe that others would have seen it, so that will play out. But I thank you again, sir, for you and your team for the presentation that would have been made today.
Right. So, Mr. Foster and Mrs. Morris Joseph, you can see that the committee appreciated the input and the sort of focus and work you did. And we have no doubt it will affect our deliberation. Minister Robinson.
It's more a clarification I'm seeking. If you utilize the internal mechanism for sending a complaint, does that open you, the complainant, to the possibility of being accused of defamation or libel if it is the internal mechanism versus somebody who publishes something which is on social media or in the public domain?
Internally, I suspect it could be privileged.
It would be privileged?
Could be. I'm not
could or would?
Well, I don't know. It depends on. It depends.
All right, that's something I think we need to examine because,
sure.
Yes, I'm concerned about the persons who want to create mischief and are deliberately malicious. But if you are utilizing an internal mechanism, then all that information is protected and privileged only to the person who is the recipient.
Right.
And so there wouldn't necessarily be the exposure of that individual to defamation or libel. And again, I want to commend the team for the thoroughness of their submission.
Just in closing, I heard you repeat what Professor Monroe mentioned about 160-odd entities, and 120 out of them are still not up to date with their financial records. Let me assure you that the present Minister of Finance and the Cabinet Secretary, they give us a quarterly report as to how, these reports. A lot of these reports are really legacy matters, and many of them coming from 10, 15 years ago. And you would be amazed the amount that we get almost on a weekly basis, which many of them are being laid in Parliament. And I suspect by the end of this fiscal year, instead of 126 not being compliant, you're going to have a significant reduction, because most of them have now brought their accounts up to date, but a lot of them are still legacy matters coming for 10, 15 years. And certainly, to the best of my recollection, most of the entities are now responding on a regular basis. So I just want to make that point since it was highlighted. Yes.
Through your chair, the issue of civil or criminal proceedings against somebody making a complaint seems to be captured in 15.2, where it says that a person who makes a protected disclosure or receives, investigates, or otherwise deals with protective disclosure shall not be liable in any civil or criminal proceeding or in the disciplinary proceeding. So it appears to me that there is protection in the current legislation.
Chair, if I might, just a last one. I have a vague recollection now of the development of this act over 10 years ago. I admit my recollection is vague, but I do, I noted when I looked at the objects of the act that talk about facilitate and encourage the making in a responsible manner of disclosures of improper conduct in the public interest. And I just wanted to get Mr. Foster's perspective on this, because as I read it now, I feel a little bit like the policy is a bit confused. And I say that, Chair, because I'm not quite clear whether this act is intended to deal with the question of improper conduct, in particular in the public service and in relation to public matters, or it is intended to create designated persons who are in effect policing private individuals in their private businesses. And why I raise this issue, and I'm asking Mr. Foster to give me his perspective on it, is because in my recollection of the development of the policy and the legislation that was passed, our focus was then on the public service system. We somehow managed to craft a bill that applies to everybody without, and I expand on Senator Scott Motley's concern, without a real understanding of how small enterprises operate. And so, Mr. Foster, as the Office of the Services Commission, could you give me your perspective on that concern? Thank you.
So we had raised that concern in terms of who does the act apply to, whether it is public or private or both. I think the clarification was given as both. However, the reason why we raised it is that in the case of the bauxite incident that was recent, there is some levy that could have been applied. So there was an instrument that could have been used and so forth. But not all organizations have that type of obligation. And while within the public sector, the designated authority follows a certain chain of command, within these small and micro media enterprise, that can also cause harm. How do you hold them accountable in the event of any disclosure. So that's where we think it was a bit vague. We thought it was very applicable to the public sector, but we thought that the private sector was a bit vague in terms of how it could be applied.
Can you explain that a little bit more? Because when you say accountable for what? Because in the context of a private, let us say you have an ad agency, for argument's sake, private business, maybe they have 4 employees, right? Perhaps there's somebody in the organization who is doing something that might be illegal, but it is not necessarily a public interest matter. It doesn't touch and concern public funds or public contracts or any of the like. Are we really saying that that's a policy we want to continue so that average citizens are in effect acting as police officers? Because that's what I see it as. Now, if that is what we want to do, that's fine. But then, if that is what we want to do, I think the protections to the person who makes a complaint and the remedies to the person who is complained about when that investigation turns nothing are woefully inadequate. And I don't think we should be turning average citizens into police officers, quite frankly, but certainly in the context of the public service system. So who is it that you want to be held to account, and held to account for what?
So my colleague and I believe that this law is more applicable to the public sector. It has a stronger bearing on the public sector. And that's why we also believe, based on the first point that we made, that a clear definition of what public interest means would give that clarity to it and zoom in to kind of narrow it down so you don't start to think too wide. In other words, if you're in a private entity and you believe that there was something that you need to disclose, then it may not necessarily be protected under this legislation because it is not of public interest. So that's why we thought the clarification would lend itself to that.
Okay, we have to cut now. We only have 15 minutes more for the last presenter. Yeah. Is that okay? Okay, go ahead quickly.
Mr. Foster, that example you gave, if I am employed to a private entity and something comes back to me as a result of my interaction with a public entity, would I therefore not, in your own contemplation of what you just said, would I therefore not be permitted to make a disclosure? Say, for example, I work with a construction company, and I notice that there are certain payments being made for work which I know that construction company has not carried out, and it is being made from a particular ministry. Would that not be in the public interest that even though I am working with a private entity, I should have a duty under this legislation, if I so desired, to disclose and be afforded all the protection?
So if I'm to understand you clearly, member, this individual works in a private construction company. If his boss was to terminate him, he's the lead contractor on the site, and he's aware of it, and he's terminated as a result of him making a disclosure. Are you then saying that the government is in a position to say to his employer to reinstate him?
No, I'm saying then that he could invoke the occupational detriment clause.
Right. So
I'm saying that the protection can't be limited to just persons who work in the public sector. I'm answering a question which you posed, right. But then which you sought to answer. I'm saying that the protection would therefore have to be afforded to that person as well, so that he could, under this legislation, get protection from, say, demotion, firing, and so on. That is my view.
Okay, point is taken.
Something to look at later. Thanks again, Mr. Foster. We're going to ask Lance to begin. I hope you can finish. If you can't finish, then we'll have to invite you back, but let's hope you can make your presentation. So if, without further ado, please start. Just introduce yourself and then so.
With due respect, if you're giving them 15 minutes, it may very be unfair to them. Better we just cut and they come back the next time and make a fulsome presentation.
How do you feel, the members from LAND? Do you feel you want to start, or you just come back? Because there's another meeting at 12:30.
If we were to come back, what date would that be?
We're looking in the first 2 weeks of, we're trying to get a date for the first 2 weeks in January.
That's
all right. So we're going to put off lands then, members of the committee, and once we do that, now could we? What is happening is that the rest of the year is booked out in terms of time. So what we're going to do for January, we have. Let's listen to the date being suggested, members of the committee. What date? No, it doesn't. Okay, two times, colleagues, have been suggested. Tuesday the 10th of January at 10 a.m., Tuesday the 10th of January.
The chairman of the PAC also has an interest in that date.
The 10th?
Given that the PAC...
No, you're on Wednesday.
I'm on Wednesday, what? The...
PAC is on Wednesday.
No, PAC.
No, but we first...
I can't get a date in December because of the bail act.
But we first on this one.
You're first way on this one?
Yeah, because you have booked it. We're booking
because Tuesday mornings are normally
so
over
Tuesday the 10th.
No, if Tuesday mornings are normally going to be frozen, then we would have to look at either the 25th of January...
All right, tentatively, Tuesday the 10th at 10 a.m. and Wednesday the 25th at 2 p.m. Huh? Wednesday the 25th at 2 p.m.? But just in the event that PAC is not sitting, let us take that date time, no?
Well, PAC has had to give up all the December dates because the committee looking at the bail act has taken all the dates in December. So we can't get a date in December to sit. So we are trying for the first available date in January.
Let's say January the 25th at 2 p.m. January the 25th at 2 p.m. Okay?
Adjourn the meeting. The minutes did recall approval needed for the hybrid meeting, so maybe in the interim that can be sorted out so we can meet hybrid.
Right. Not at the moment. What I would like to do first is to see if we can get the presentations out. Okay, and once we get the presentations out, then we can look at hybrid discussions. Right? But I think it's useful to have the face-to-face presentation, if you don't mind. So the next meeting of the committee then is Wednesday the 25th at 2 p.m. and we'll invite Lance and please many of the other members to come because we might have to go from 2 to 5, something like this, so we can really try and get through and maybe at most one more meeting to take all the presentations. So thanks again, members, for your presence, and also thanks for the interaction. Thanks again, everyone, for being here. Thanks to CPC Law Reform. Okay? Thanks again, Mr. So meeting adjourned until next time.